No nation can call itself great if the impartiality of its courts is doubted. And we stand at a crossroads in history where today more and more Indians are doubting the higher judiciary and its ability to deliver an open justice. Why, viewers? Why is this the case? Because jurists, lawyers, commentators and observers say that the courts in our country refuse to open themselves up to impartial scrutiny. Even a school-going child will tell you that there is deep conflict of interest at work if a system sits in judgment of itself, or when a group sits in judgment of its own members. That's happening in our great India. The judges judge themselves. The Supreme Court refuses to listen to demands being made by officers of the law to initiate criminal proceedings against Justice Varma as new facts emerge that prompt more and more unanswered questions. So serious is the situation that a growing number of bar associations from across the country have been compelled to raise the banner of revolt. Their heads, their leaders have landed in the Union capital and joined the Allahabad High Court Bar Association's protest against the decisions of the Supreme Court Collegium in this particular case, which involves the recovery of unaccounted cash, viewers, from a justice's premises. But first, let's examine some of the unexplained twists that are agitating the extended legal fraternity and, frankly, even the citizenry. Several reports have emerged in the media that raise some disquieting questions. Viewers, there are no leads on CCTVs on illegal entry into the storeroom of the Justice Varma's home, viewers. Now, we had been given to believe by some people close to the investigation some days back that there is a possibility that money could have been planted there. Viewers, the CCTVs are showing no illegal entry into the storerooms. There is no spot panchnama filed on the night of the blaze. This is highly irregular. At least 5 witnesses are needed to testify to the condition of the premises on the basis of which a panchnama is drawn up. But it wasn't. 5 policemen, first responders at the site when the fire was raging, were asked to return in the morning. Why, viewers? We don't know. Was there something to hide? It took 8 hours for the police headquarters to learn of the blaze at Justice Varma's home. 8 a.m. on March 15, additional DCP presented the morning diary to his seniors. The morning diary also was shared with Delhi Commissioner of Police, who was shown videos captured after the blaze. Viewers, presumably it is from there that the videos were made available to the Chief Justice, and it is presumably from the Chief Justice, I don't know, that they made their way to the web page of the Supreme Courts. As more and more information begins to do the rounds, beleaguered Justice Varma has begun to consult top lawyers in an attempt to prepare a response that he hopes, viewers, will provide him cover and stave off a criminal investigation. We are being told that Justice Yashwant Varma and some of these lawyers were seen going into his residence yesterday, met a team of lawyers to seek legal opinion. Senior advocates Siddharth Agarwal, Arundhati Katju and advocates Tara Narula, Stuti Gujral apparently were also consulted. Justice Varma is seeking legal advice on how best to craft a response to allegations ahead of quizzing, which is imminent, by the in-house Supreme Court appointed inquiry committee. But the new details that have emerged have only served to intensify the stir against the Supreme Court Collegium. As mentioned earlier, several bar associations have lined up to lend solidarity to the Allahabad High Court Bar Association in its fight, viewers, for a transparent investigation. Why does the judiciary have to be reminded of this fact? Several bar associations of the various high courts have lent solidarity to the stir by the Allahabad High Court Bar Association. The bar association heads have landed up in Delhi from different states, issued a joint statement. More than a dozen bar associations demand the initiation of criminal investigation against Justice Varma. Need I tell you, viewers, that in the past, certain judges have faced intense scrutiny, parliamentary scrutiny, where impeachment motions were made. But before they came to their logical conclusion, these justices, in their wisdom, resigned. And guess what, viewers? Nothing was done after that. No FIR was filed, no criminal investigation launched. We don't know what happened. Obviously, if the impeachment versions were coming to some sort of fruition, there was some smoke. So why wasn't there a formal investigation? Will that happen now? In this case too, as the leaders of the bar associations meet with top government functionaries in the capital and even the collegium, they've also listed what they say are insoluble demands. Quote, as per report of the Chief Justice of the High Court of Delhi, somebody removed the articles from the premises on 15/3/2025 and had the criminal law been sent on motion, the evidence would not have been destroyed. Reassess the current in-house procedure approved by the Supreme Court in 1999 and restatement of values of judicial life as approved in 1997 following by the Bangalore Principles of 2002, unquote, are two of their big demands. As of now, there is no indication that the Supreme Court Collegium is going to budge. In its meeting with some of these bar council heads, it is assured that they will look favorably upon these demands. So far, viewers, no word. This prompts us to ask if the decision to appoint an in-house panel is in the interest of advancing open justice. Why are so many bar associations dissenting? By avoiding filing an FIR to initiate a criminal investigation, has the Supreme Court opened itself up to a conflict of interest potential charge? By not ordering a criminal investigation, has the Supreme Court lost an opportunity to convince the public that it is keen on advancing accountability within? These are some fundamental questions, and one has to ask some of these questions. And I want to first begin with SMA Kazmi, who's a senior advocate. He was here with us a couple of days back. Why? Because he represents the Allahabad High Court, at least one of the Bar Association from there, at least he's one of those members. So I want to ask you, Mr. Kazmi, we're seeing this stir by the bar associations now expanding. So it was the Allahabad High Court Bar Association first. Now there are several other adjuncted bars that have come together, some from the state of Uttar Pradesh also. Now some people are saying that people like yourself are playing a political hand, that you are being pushed by certain political players who want to exert executive control using this issue upon the judiciary. First, tell me if this is true or not. And secondly, your leaders have met the Supreme Court Collegium. They have been able to table some demands. The Supreme Court Collegium has said, we'll look into it. So, are you planning now to call off your strike? If not, why?
As of now, as your specific question is regarding the strike, we plan to continue the strike tomorrow. Okay. And tomorrow we will be having a meeting. The Bar Association will have a meeting and we will decide further course of action. But as of now, tomorrow we are on strike. As far as the investigation is concerned, how we are not satisfied with the in-house mechanism of the inquiry. You see, we cannot afford to let the people of the country lose faith in the judiciary, because the hallmark of the entire judicial system lies on the integrity of the people who are appointed as judges. Well, if there is a doubt in the ordinary citizenry in their mind that the judges can be corrupt, or in case they are corrupt, then they are getting shielded. There may be a mechanism in which a blanket is being put over the entire issue. That would create a doubt in the mind of the citizenry, which will demolish the entire judicial system. So in this particular scenario, I am not jumping to conclusion whether the particular judge is involved in any kind of corruption or not. But as soon as we were told that he was not in his residence when this incident occurred, that was on 14th. What took the judiciary another 5 to 6 days to come up in the open? A, why was he allowed to re-enter the premises? Why his own bungalow? Why was that area not cordoned off? What was happening in that bungalow premises for next 5 6 days? B, C, that only after a particular video was leaked had the entire nation got to know about this.
It wasn't leaked, it was actually put
required.
out there, wasn't it?
Yes, so what was it even required? Ideally, the ideal situation in order to justify the morale of a judge would be all right. There's a particular stash of money found in my premises. I am not going to visit that bungalow again. I am not going to sit in my court again. And I'm offering myself to probe of any kind by CBI, by ED. Let me come out clean and then I will visit back my bungalow and I will sit in court. This action would reinforce the trust in the judiciary of the ordinary citizenry.
Okay, so you have a problem with this sort of in-house inquiry without a criminal investigation. That's what you're saying, basically.
And judges should be at par with politicians and with bureaucrats if such a situation does occur. Otherwise, brick by brick, the wall of trust of judiciary will fall.
Okay, so let me ask Abhijit Iyer Mitra to weigh in. Now, Abhijit Iyer Mitra, you represent a citizen's point of view. A large number of citizens, such as yourself, are beginning to question the judiciary and this sort of perceived wall, this ivory tower called firewall that is sort of built around the judiciary that makes it sort of above question a closed sort of system. Now, the collegium had been guided, from what little I can tell, by the current in-house procedure approved by the Supreme Court in 1999 to order this in-house inquiry. It was just following to the letter the procedure that has been set down. It's a 7-step phase, as you know, a 7-step procedure. So why do we have a problem with that? Don't we trust the judiciary to do an exemplary job of cleaning up the rot if there is rot?
Unfortunately, Rahul, the problem is that very often these procedures don't follow the rules laid down by the Supreme Court itself. Do you remember there is a 2-tier justice system in this country? Do you remember when the entire Justice Ranjan Gogoi scandal had broken out? It turned out the Supreme Court didn't even have a POSH committee, Prevention of Sexual Harassment Committee. The allegations made, had it been made against any one of us, it would have been an immediate arrest. That poor girl, handicapped girl, was taken in. She wasn't even provided a interpreter. She had handicaps. She wasn't provided with any speech interpreter or whatever. And the judge, the accused in question, sat and presided over his own proceedings. There was another case of a suicide just 4 or 5 months back, Mr. Atul Subhash, where very serious allegations have been made and there has been zero investigation into the judge concerned. Here, there are many issues here which simply violate their own standards and procedures. It was 6 days after the incident that the story broke cover. Now, the gentleman at whose house, now understand, Rahul, if your house, my house, or anybody on this panel's house had found this much cash, we would immediately be in custody. But even basic procedure like a seizure note was not provided. The judge in question, he has every right to say that I don't know where this cash has come from. He knows the procedure. Why didn't he file an FIR and investigate criminal inquiry into where that cash came from? He knows the law. He could have filed an FIR and said somebody has framed me and put money out here. Why did he not do it? You know why? Because it then takes it away from the judiciary and makes it a normal criminal investigation which ED, CBI or the police can enter. There is a lot out here which is showing that there is a very clear caste system where there are some Brahmins and there are some untouchables, and there is real life discrimination happening, that the law is different for the high and mighty and the law is different for the ordinary citizenry out here. And I'm sorry, nobody here is covering themselves up in glory. The Delhi police and the fire service, they deleted their phones to prevent, you know why? Because it triggers something called Section 65B of the Evidence Act.
No, but how do we know this?
And there is a whole there is a whole cabal of fixers that I call the Gang of Five going around doing this right now in Delhi. 65B is what? Assume there has been a murder in my house and I have videographed it on my phone. I transfer it to you on WhatsApp, fearing for my life. But say the cops come in time and I'm saved. But I lose my phone in the process. I have recorded the person who killed my family or whatever to you, but it is inadmissible because my phone, which was lost during the process, cannot be certified anymore. There has been deliberate attempts at destruction of evidence out here. Both
Well,
by
I
the
mean, this
police
is all
and
alleged, of course. I mean, this is all alleged.
No. We know this for a fact.
Now, how do
we
we
know
know
this
this
for
for
a
a
fact.
fact? I mean,
It's been announced in the news today that their phones have been sent. All the police phones have been seized.
Yeah,
and
but
it's been
that might be a matter of routine. Look, I mean, okay, you know,
no.
Mr. Mitra.
Rahul.
Yeah.
Rahul, why do policemen wipe their phones clean?
I mean, this is an assumption. We don't know what is going to come out of those.
All the policemen at the spot wipe their phones clean is an assumption.
No, actually, you know, no, Abhijit Iyer Mitra, I'm not doubting what you're saying. I'm only saying that, you know, for the sake of keeping up appearances, as they say, we have to be a bit careful. Because as you know, the long arm of the law, you know, the contempt laws, this, that, the other, I'm just a bit worried about that. But I can understand. Look at these apprehensions that Mr. Mitra, viewers, is expressing. And Mr. Som, I have to ask you this. By avoiding filing an FIR, to initiate a criminal investigation, as the bar associations are demanding, as you know, our fellow brother who is sitting here on our panel, Mr. Kazmi, is demanding, has the Supreme Court lost a golden opportunity to convince the public that it is keen, that it is desirous of advancing accountability within its own ranks?
Rahul, you will have to give me a patient 2-minute hearing to
Yes.
explain that why, you know, the FIRs are not happening. See, first of all, having an unaccounted money of this amount at a sitting High Court judge resident, in my view, is the highest form of judicial impropriety. Having said so, I am also conscious of the judgment of 2014, which prescribes a procedure for removal of a High Court judge when an allegation is made. So this word allegation is important, Rahul, because we are at this stage now. Now a committee which is formed is not of a common man or you know, investigating officer. The committee comprises 2 sitting High Court Chief Justices and 1 High Court judge. Now what is the role of the committee? So when they find that there is a substance to the allegation, they submit the report to the Chief Justice of India, and the Chief Justice of India asks for the resignation of the judge, or if he doesn't resign, then sends a report to the President and the Prime Minister of India to take a action for the removal of the same. Now, till the time the person is a High Court or a Supreme Court judge, he is under a immunity. Why? I'll tell you. Because in India, in Indian courts, the biggest litigator is government. Government means government agencies, government departments. So by no stretch of imagination, government departments can initiate an inquiry against a sitting High Court or Supreme Court judge because they are deciding their cases. Having said so, even the basic structure of our constitution talks about 3 very important things: separation of power, independence
Mr.
of
Som, those are
judiciary,
different issues.
and judicial review.
One second, I want to come back to the point you're making. Look, it's very simple. I know that it all comes back to the Chief Justice. All he needs to do is to say, yes, I would like X or Y agency to investigate this matter. That is why I asked you, the question was, by not ordering a criminal investigation, has the Supreme Court lost an opportunity to convince the public that it is in the interest of furthering a degree of transparent accountability within its ranks? I mean, this is not a procedure question. Why are you making it into some rigmarole?
No, so I'll tell you, Rahul, even a criminal investigation can happen by the agency, maybe CBI, ED or other government agency. But once it is determined that the allegations are true and a judge is asked
why?
to
How do
be
we know?
removed
Even if
from the
supposing,
bench.
no, hang on, Ayyar
Then
Mitra,
he doesn't
are
remain
you,
a judge.
do-
Now
what do
I
you
tell
make
you,
of this?
there are
No,
precedences.
no, one second. The
I tell
people
you,
who are
see,
sitting
there
in
are
judgment of the
precedences
justice
where
are his
former
brother.
High Court judges
No, please,
face
Mr.
charge
Som,
sheets,
look, this is not making any
CBI,
sense to me.
CBI investigations.
No, no, look, there is a procedure. I agree. There is a procedure laid
It will
down.
not because
No, no, one second,
the
one
answer
second,
which
one
you
second.
want
Ayyar
from me,
Mitra, let
I
me
will
just
not
bring in
budge
Mr.
to
Ayyar
that.
Mitra. One
I will
second.
only tell you what the legal point
No,
is.
I know, great. Viewers, this is a problem. We've all become lakir ka fakirs to the point where we lose track of even where the lakir is. This is the point, viewers.
Rahul, can
the
I-
procedure,
can-
the
can-
procedure
can I
doesn't
make
need
one
to be. No,
very
hang on.
important
The
point?
procedure in
Do
no
you
democracy. Just a
do
minute,
you
sir.
remember
Mr.
a
Som,
time
1 second,
when
please. 1
Justice
second.
Jagmohan-
Let's not speak
Jagmohan
over each
Sinha-
other. Mr. Som, let's not speak over each other. Let's do us, each other a favor. I'm not contesting what you're saying. I'm only questioning the logic here. You are right. There is a procedure. But, sir, blind adherence to a procedure that may or may not evoke a sense of confidence is also not right. And let me tell you, if people are desirous of wanting to come clean, they might want to readdress the procedure itself. Am I wrong, Ayyar Mitra?
So, this is the problem. When we talk about checks and balances in this country, every other arm of government has a check and balance except the judiciary. Okay? Investigation is not the role of the judiciary. They've abrogated this right onto themselves. Fundamentally, when you say judge, jury, executioner all rolled into one, it implies a violation of check and balance. Here, the investigator, the jury, and the judge is investigating the investigator, jury, and judge. Have you ever heard of such an absurdity?
No, that's why I began by saying
come up
that
with things like the collegium. The collegium is legal fiction invented by the Supreme Court, where the constitution has become an optional extra. You find me one word in the constitution that says collegium, kuch nahi. So, we are looking at a very, very serious crisis right now, where checks and balances are being egregiously flouted by procedures that have come up that are fundamentally, in my opinion, extra legal.
yeah,
Where the law is subverted.
Look, Ayyar Mitra, what you're saying has been repeated by some very top jurists and very, very senior lawyers on this show who have been office bearers, AGs and SGs. So, what you're saying is not completely some sort of, new critique.
Yeah.
This is well-established logic, and therefore I want to bring in a person who wears also a political hat but is also an advocate, Tausif Khan. Now, Mr. Khan, look, if supposing the judiciary decides to embark on the procedure that it has embarked upon, it is for Parliament then to step in and look at ways of addressing this issue. But the party that you are sympathetic to, the TMC for example, and some other opposition parties, are refusing to cooperate with the government to come up with a solution that would be acceptable without crossing. I'm not saying that you cross the fundamental divide between the judiciary, the executive and the legislature, all the separation of powers. But you can work out via media. Why are you not even wanting to have that conversation? Why are you actually attacking media and others who are wanting to bring these facts out, saying that they are, or insinuating rather, that they are playing some game where they want to advantage the executive so that the executive can control the judiciary? I think there is some oddity here, Tausif Khan.
I don't think any of the opposition parties is opposing the idea to find a solution to a menace like this. You see, the public, the confidence of the public is not shaken by the fact that cash is discovered at the judge's house, or that there is a possibility of corruption at the highest level of judiciary. No, public's confidence is not shaken by that discovery.
Oh, really?
Public's confidence will be shaken. Public's confidence will be eroded if this matter does not see the light of the day, if the truth does not come out, if no befitting action is taken against the judge. Now, when action is taken against the judge, there are twofold action that is required to be taken. One, that he should be taken off the roster. He has been already taken off the roster. Now, the Supreme Court wanted to throw him back to Allahabad High Court, and the Allahabad Bar Association is opposing that. that he should not be assigned any judicial function now. That is point number one. Second, if he is at all involved in any corruption, then what punitive measure is taken against him under the Prevention of Corruption Act? So there are twofold action that is required to be taken. One,
Tausif Khan, we know that. I'm asking you the question that follows.
That can happen only through
one second.
process.
See, the problem is that you are saying if. This will always remain in doubt, Ayyar Mitra. It will always remain in doubt because, as you have said, the judge, the jury, and the executive.
After the inquiry, this doubt will be removed.
No, but how do we know that how do you know? How can you put your hand on your heart, Mr. Tausif Khan, and say that this particular inquiry conducted by judges to investigate a brother judge will be above any conflict of interest?
No. Please understand. Please understand that a sitting High Court of a judge is equivalent to the rank of a state cabinet minister. A sitting High Court of a judge holds a diplomatic passport.
No,
there are lots of powers involved. Yes,
hang on. Are you saying? Hang on. Let's extend this logic.
But that does not
Tausif
stop
Khan's
him
logic,
from an
viewers.
FIR.
Tausif Khan's logic is the following: that if the
Nothing
Prime
stops
Minister
the
discovers
court
that there is a
from
corrupt
filing
person in
an
his
FIR
cabinet.
against
No, one
the
second,
against
Tausif Khan,
Justice
please.
Varma.
If the
Yes,
Prime
that
Minister
should be
discovers that there is
investigated by the
somebody
investigative
corrupt in his
agencies
cabinet,
like ED
then
and
the Prime
CBI.
Minister
I
should
am
set up
totally in
another
favor
group
of
of cabinet ministers, including himself, to judge that person. And then, whatever comes out of it, we should accept it. Viewers,
As long as they have a red
Of course
diplomatic
not.
passport.
Of course not. This is an institutional matter. Chief Justice of India. No, please do not.
No, then
do
why
not
has the
make
Bar
this
Association,
a trivial
have they
issue.
lost
It's a
their
very
mind?
serious matter.
The Bar
It is a
Association that is striking
serious
work,
matter.
that is inconveniencing hundreds and thousands of litigants, and they are demanding that a criminal investigation should be ordered. Have they lost
Bar
their minds?
Association is right.
So then, how can two people,
Yes,
how
Bar
can the
Association
collegium
is
be
right.
also right
They
and the
are
Bar
right.
Association
They
be
are
right?
right.
No, one
Bar
viewers. Okay,
Bar
look,
Association is right in demanding an FIR.
Okay, but there has been none.
The collegium is
So,
only
so
following
who's
the
showing
procedure.
that clean?
Nothing stops them
Who's,
from lodging
if
an
that is
FIR.
the basis, then why hasn't it happened? Viewers, this is what I'm saying. Logic is circular in some situations. You come back to the same point because it is the most logical point. The starting point here is problematic for me. The starting point here should have been a FIR. It should have been launched. A probe should be also proceeding. And this is what the Bar Association is wanting from the collegium. Because I leave it at this, because these questions are not going to end till someone comes out and tells us why a different path has been chosen and what sense that path is making. How is that going to actually advance the sense of justice, open justice? We are not going to give up on this story, viewers, because this affects all of us. As I said, and I began by saying, no country can rise above the standard of its justice system. If that is compromised, viewers, the country itself is compromised. I leave it at that. Viewers, after Congress in Karnataka used its brute majority in the state assembly to pass a resolution against the new Waqf Amendment Bill sought to be passed in the Union Parliament on April 1st, the DMK in the Tamil Nadu State Assembly has also piloted a resolution against the proposed legislation. All of that, viewers, has happened today. The resolutions passed by both states deemed the new Waqf Amendment Bill as a major assault on Muslim rights in the country. Not just that, but the resolutions say that the proposed law, if passed by Parliament, will usurp and abridge the executive and legislative jurisdiction of the state government over issues related to Waqf land that fall under the concurrent list. For the uninitiated, the concurrent list is a list of issues over which both centre and state have oversight. Legislative oversight, administrative oversight. The resolutions say the new Waqf bill is against the principles of equity, equality and parity as enshrined in the Constitution. The AIMPLB, or the All India Muslim Personal Law Board, has also launched a campaign against the proposed legislation, warning Muslims that their masjids will be taken away from them. if the centre carries out the amendments. While it is expected of the opposition, of even the AIMPLB to criticize the centre, to draw up the spectre of all sorts of persecutions and discriminations against Muslims, curiously, an attack is also being mounted upon the government from an unexpected quarter of civil society. Lawyers like Vishnu Shankar Jain and citizen voices like Dr. Ranganathan, who wanted regulations against Waqf bodies, are saying that the new amendment bill doesn't go far enough to curb the allegedly arbitrary powers of the Waqf to seize lands. They would much rather see entire Waqf Act as it exists today to be abrogated, to be struck down. What are the facts? Let's debate by bringing together two individuals that usually agree with each other, but are on opposite sides of the divide on this one contentious piece of legislation. Viewers, before you think there's a meltdown in one particular ecosystem, don't, because this just points towards the great democracy we have and continue to have. Let's open this up, viewers. Let's ask and begin with Dr. Ranganathan and Shahzad Poonawalla. They're the only two here on this panel. Dr. Ranganathan, why do you think the government has not gone far enough with the Waqf Amendment? Let's try to curtail answers within 230 minutes.
Hello, Rahul, and a very big hello to my brother Shahzad. Look, I think there are two issues out here. Yesterday, as you know, my family and brother Shahzad, has in a delightfully combative mood, drew an analogy of Waqf Amendment Bill with the abrogation of Article 370, saying that amending of the Act is like abrogating 370, and ultimately it would be abrogated just like 370 would be. With respect, I think the analogy or equivalence, if I may call it, is flawed for two reasons. A, the clause that remains in 370 is a neutral and vital clause that says Indian Constitution is applicable to Jammu and Kashmir, whereas the clauses that remain in the amended Waqf Bill, hundreds, are draconian clauses that will continue to cause irreparable harm to the non-Muslims and their property in this country. Number two, is it the BJP stand that the Waqf Act will be totally abrogated soon and that this amendment is only a stopgap interim measure? If yes, then they should say it publicly, and I congratulate them and ask for a timeline for the total abrogation of the Waqf Act. Now to the second point. Rahul, as I've said this ad nauseum, unjust, discriminatory, draconian acts are not amended, they are abrogated. So do not amend the Waqf Act that has usurped lakhs of acres of government, Hindu and temple land, abrogated. But I think one has to be reconciled with the fact that this government will not abrogate the Waqf Act. At best, it is only slightly going to, after a prolonged CAA-like struggle, the amended Waqf Act might come into force and acceptance. But as I said yesterday, an amended Waqf Act or bill is just slightly less draconian than its draconian parent act. So I am resigned to this discrimination continuing. Therefore, as I said, the only other logical recourse is for me to ask for such a discriminatory and draconian act being promulgated for Hindus as well. If you cannot remove discrimination against Hindus, reward them with it in the form of a Sanatan Act, the exact clause for clause replica of the Waqf Act. Look, I have absolutely nothing against the Waqf board. Why should anyone? Countless boards, thousands of them, charities, NGOs exist in this country. Right. The problem is the Waqf Act. I repeat, the issue I have with is the act, not the board, because Rahul, the world over, disputes over property are settled using courts and existing laws that are community and religion agnostic. So why should a particular religious community, Muslim community in this case, be armed with another set of laws? Those that are patently discriminatory towards member of other community as a primary instrument of defense or indeed offense. Okay. So is there a Hindu equivalent of the Waqf Act? Promulgate one. Okay. I just want to end with this. The fact of the matter is, let those who want continuation of the Waqf Act watch as Hindus will lay claim to thousands of mosques and Muslim villages and then enjoy the privilege of disputes being addressed primarily not through the courts, but via the clauses and strictures of the Hindu Equivalence Act. Okay. Within 24 hours, all those demanding Waqf Act
will come in line.
Okay. Mr. Poonawalla, your response to the opening remarks, amended Waqf or not, the new law still doesn't solve the problem of legalizing religious asymmetry. That's really what Dr. Ranganathan is getting at here. And this also falls foul of the principle of the UCC. Go ahead.
All right. First of all those people who are now sitting with popcorn in their hand wondering whether Anand and I are going to fight, well, this is how mature democracies behave. We don't get down on the streets saying Shaheen Bagh bana denge ya sar tan se juda karenge. So I appreciate this attempt to have this conversation, which is a mature conversation. But I just have one condition. Like I heard Anand Ranganathan patiently, there will be some interventions I will need from him, but those interventions should be short only in yes or no, because Anand Ranganathan has often done that with his other panelists. And therefore I begin with Anand Ranganathan. The long speech that he made about the pitfalls of this new Amendment Act. Anand, where have you seen a copy or the draft of this new Amendment Act?
I have read.
Can you answer
PDF
yes or no?
version
Have you
of
seen
it.
a copy, yes or no?
Yes, yes.
1 second. Now, yes, okay. Now, Rahul, just for the viewers' information, there was an Amendment Act introduced in 2024 in August in Lok Sabha, which was then sent to the JPC. On that particular act, by the way, and I will make you hear, both Vishnu Jain and Anand Ranganathan have endorsed support. After that, the JPC came out with its recommendations and a report, of which there are certain amendments that have been suggested. Those are non-binding. So whether those will be accepted in full or partially or otherwise, we don't know till the time a draft on the basis or in the light of that JPC report comes out. So all that Anand Ranganathan has said is purely in the realm of speculation. It reminds me almost like another actress of Bollywood who was saying that I am against CA NRC, and when the anchor asked her, where is this NRC draft? She said, I don't have it, I read somewhere. I mean, Anand, where is the fresh draft that you're basing this accusation on? And 7-8 months ago, when it was passed in Lok Sabha and then sent to the JPC, at that time, I want to make you hear what Vishnu Jain said. And Rahul, in the interest of fairness, please do not cut out this part.
95 मैंने काफी डिटेल अध्ययन किया है, साथ ही साथ जो अमेंडमेंट बिल आया है उसका भी काफी डिटेल अध्ययन किया है। अब देखिए, अभी यहाँ पे वारिस भाई ने कहा कि काफी बातें उन्होंने कही, मैं उनसे पूछना चाहता हूँ बहुत ही संजीदगी से, अगर ये आज डेफिनेशन में अमेंडमेंट किया जा रहा है कि वफ आप उसी को वफ कर सकते हैं जो आपकी खुद की ओनरशिप में है, किसी और की संपत्ति को वफ घोषित नहीं कर सकते हैं, इसमें क्या दिक्कत है? अगर आज ये अमेंडमेंट किया जा रहा है कि सरकारी संपत्ति को वफ संपत्ति नहीं घोषित किया जा सकता है, तो इसमें क्या दिक्कत है? अगर आज ये अमेंडमेंट किया जा रहा है कि पहले के एक्ट में जो वफ संपत्ति घोषित हुई है 6 महीने के अंदर उसका ब्यौरा दे, उसकी बाउंड्रीज दे, उसके मुतवल्ली बताएं, तो इसमें क्या दिक्कत है? अगर आज ये अमेंडमेंट किया जा रहा है कि कलेक्टर उसका सर्वे करेंगे, सर्वे कमिश्नर नहीं करेंगे, किसी को पता ही नहीं सर्वे कमिश्नर की क्या क्वालिफिकेशन, सर्वे कमिश्नर कौन होगा पता ही नहीं, स्टेट गवर्नमेंट जिसको नियुक्त करते हैं वो सर्वे कमिश्नर है, उसको कलेक्टर को लाया जाता है, उसमें क्या दिक्कत है? लाया जा रहा है अमेंडमेंट कि सेक्शन 40 में जो असीमित अधिकार दिए हुए थे कि आप किसी भी संपत्ति को वह संपत्ति घोषित कर सकते हैं, जो इस्लामिक लॉ के भी खिलाफ है, अगर उसको डिलीट किया जा रहा है तो क्या दिक्कत है? अगर आज इस देश के कॉन्स्टिट्यूशन के साथ तो ये लाया जा रहा है कि जो 3 जजेस होंगे वह ट्राइब्यूनल में, उसमें एक जज के क्राइटेरिया था कि इस्लामिक लॉ का जानकार होगा, उसको हटाया जा रहा है, सिर्फ 2 जज रखे जा रहे हैं, तो उसमें क्या दिक्कत है? अगर राइट टू अपील दिया जा रहा है हाईकोर्ट में कि हाईकोर्ट जाइए वह ट्राइब्यूनल के खिलाफ और वहां पर निर्णय, वहां पर उस फैसले को चुनौती दीजिए, तो उसमें क्या दिक्कत है?
Now, Rahul, please be charitable to me. I want to tell you, first of all, there is no current new law that has been brought into Parliament. So what is Anand basing his objection on? We don't know. The last draft that was there was endorsed heavily by Vishnu Jain, as I have made you hear. In fact, Vishnu Jain not only endorsed the idea of having a tribunal, he extolled its virtues because it would now have a judge, not an Islamic preacher. He also spoke about how Waqf by user comes to an end, how government property that was captured by Waqf now comes to an end, how the Waqf bodies would be more representative. All of these things have been endorsed. And therefore, now I have 2 or 3 questions that I want to ask Anand Ranganathan. Anand, please tell me, you're a scientist. Many times you devise a vaccine and then in the later years you devise a better vaccine which is more effective. Do you mean to say that the first version of the vaccine is developed by somebody who was not essentially fighting the virus? To say that is to not understand how laws are made. Laws are not final destinations. Laws are work in progress. There will be a law that will come out. Once you have seen a draft and you oppose it saying that it is not strong enough, I can understand. But right now, what are you basing it on except for the fact that you are going by the intent of the government? And if you are going by the intent of the government, and I will end in the next 30-40 seconds, Anand, this is not personal and don't take it in that spirit. Prior to 2014, you have written very vehemently about many issues. You've written about how nationalism is not a good thing. You've advocated how there should be no firecrackers during Diwali. Please show me one article you have advocated asking for Waqf to be repealed prior to 2014. If you have it, like you quote Ambedkar's book, quote that article to me right now.
Yeah.
Okay,
Please.
can I respond to
Of
that?
course, of course.
Yeah, no, thank you very much, Shehzad, for those interventions. And I'm glad you might think that I look like Vishnu Jain, but I am not. All those points that you raised that now Vishnu Jain is opposing it, but he was for the Waqf, those answers would be given by Vishnu Jain, not I. You did not say that I wanted or was okay with the Waqf Amendment Bill ever. You showed the videos of Vishnu Jain. Show me, I challenge you, a video of mine where I say I am fine with the Waqf Amendment Bill. Because as far as I can remember, from the very beginning, I have said, and I said it here as well, I work on first principle. Why should the Muslims have a separate parallel act in dealing with matters that the non-Muslims deal with the courts? So that is my first principle. That's point number one. Point number two, I have gone by the Waqf Amendment Bill, that is a PDF is present on PRS India. Yes, if all what I say has been incorporated already or will be incorporated in the final bill, then I'm fine with it. But as I said, my being fine with it would only mean that every draconian clause of the Waqf Act has been removed. And I am telling you it won't be. Otherwise, you tell me what are the acts and clauses that have been removed. I can only go by what is the PDF version on the government website. You can't expect me to be in the internal coterie of BJP as you are to decide what is going to be the final version. And the last point you made, I have myself accepted, in fact, I've written a book on it, prior to 2016 or 17, when I learned about the draconian versus the Waqf, I knew nothing about the Waqf Act at all. So for you to say that in 2014 I was silent about it is a non sequitur, because I didn't know anything about the Waqf. But the moment I got to know about this draconian act, like I'm sure, the moment you get to know about something draconian, you start protesting about it. Likewise, I didn't know much about Article 370 or the... One second, let me finish. As I did, I allowed you to finish, your long interjection. For example, the moment I got to know about the conjunction of 93rd Amendment with the RTE Act and how draconian it was and discriminated against the Hindus, I protested against it. But before that, I did not know the conjunction, and I was for the RTE. So as new facts emerge, as I learn more, I base my thing on that rather than having
I think that's a fair point. That's the latter point is a fair one. Yes, Shahzad Punawalla.
Anand, yeah. Now see, I am glad that firstly Anand has conceded right at the very beginning, just like Swara Bhaskar had conceded, that he has not seen the fresh act which has come post the JPC amendment being suggested. He is going by the draft, in his words, of the PRS, which is of the 2024 August draft. There is no other draft, and Rahul, as a journalist who speaks about hard facts, you will also confirm that till now no new bill has been introduced on which Anand can base all his fears or his presumptions. Point number one. Point number two, Anand, I may be an insider in the BJP, I am actually the national spokesperson of the BJP, but this is solely in the domain of the cabinet and the parliament, and therefore I am not like a Barka, that type of journalist, that despite my position I will know what is going on inside the government. The government, when it takes a decision, it will bring a draft to the cabinet and then to parliament, and that's when Anand Ranganathan and Shahzad Punawalla both will know it, despite my privileged position of being a spokesperson of the BJP. That's how the BJP works, and I'm sure you know about it. That's why you are also supporting Prime Minister Modi's many of his initiatives. The reason, please, Rahul, this is not fair. You gave a very long period of time and you also summarized his points. You let me complete. Please, don't be unfair. Don't be unfair. Or go by the clock. Thirdly, the reason I quoted Vishnu Shankar Jain, and Anand, you do not look like Vishnu Shankar Jain, but Vishnu Shankar Jain looks extremely good as well, just like you. The reason I quoted Vishnu Shankar Jain to you is because Rahul in his opening spoke about Vishnu Shankar Jain and labelled him or clubbed him along with civil society activists like you. And in fact, you and Vishnu Shankar Jain, by the way, have done a video, not one, many actually on YouTube, on the Waqf, where he has spoken on the exact same things. Now I ask you, when you knew about Vishnu Jain's position in back then, why didn't you go ahead and tell Vishnu Jain?
Okay, I can help here.
In 2024, you were supporting these positions. Please, Rahul, do not do this unfairly, or else I will walk out. If you want to be unfair to me, you allowed Anand full time.
I'm not being unfair. I just
if
want
you
to
have
bring
an
in a
agenda,
clarification why
let
I
me get
used
complete.
Vishnu
You have
Shankar
interrupted
Jain
me twice unnecessarily.
Okay, carry on.
But let me complete, Rahul. You are being unfair and you are destroying my entire flow.
Carry on.
It's very unfair, Rahul.
Carry on.
Rahul, you have quoted Vishnu Shankar Jain for whatever reasons. You have the full right to.
Yeah.
Anand has done videos and YouTube videos with him and sessions with him. Okay. He has a right to still have an independent view. But all I am saying is that Rahul or Anand did not counter Vishnu Jain when he was praising this amendment in 2024 August. At that time, why didn't Anand say to Vishnu Jain that you are wrong, or in his interactions with him? But forget that. Anand says that I go by the hard facts, by the basic principles. Anand, do you know that apart from this non-existent law which you are critiquing so vehemently, there is another law in 2023. Do you know which law that was about Waqf that has been introduced in the Rajya Sabha? Can you just tell me whether you know about the law, yes or no?
Which law was
Are you aware of
introduced?
that law, yes or no?
There was a law
In
that
Rajya
was
Sabha,
introduced
which bill was introduced?
2013, I think it was,
which
but-
bill was introduced in 20? No,
It
I'm
was
talking
for
of 2023.
Rajya Sabha,
Do you know that
23.
another bill? Do you
Was
know
it
of
for
the other bill that has been
encroachment
introduced in 2023?
Waqf
No, it's
encroachment.
not. Now let me tell you.
Okay.
No, it's not. Wrong. So Rahul and Anand, the point I'm trying to make is that here is a situation where a new law has not come, but Anand is critiquing it. But Anand has missed the bill that has been introduced in December 2023 in Rajya Sabha, which calls itself Waqf Repeal Bill, which aims at completely repealing the Waqf 1995 Act. And therefore now I ask Anand, a man of only facts, if you had to critique something which is on the table, this bill was on the table. You left this bill and you are critiquing a non-existent bill. Therefore, now I ask you, Anand, that is your critique only meant for critique, or is your critique actually driven by something substantive? If yes, tell me the provision you are critiquing.
Okay, go ahead. I want to just, before
Okay.
you go ahead, Doctor,
Yeah.
just one small thing, caveat. You see, I invoked Vishnu Shankar Jain because I interviewed him yesterday. And he says that this Waqf Act that is going to come is not substantial enough. In fact, I'll try and ferret out that soundbite. So he's resigned from his position. I don't know on what basis. My fault, I should have asked him. But he also believes that there will be challenges to this Waqf Act as and when it becomes law. That I just wanted to make that point. So I don't know what happened before this. I don't know why he said what he said, but he's resigned from his earlier position. That's all I wanted to say. Yes, Dr. Ranganathan.
Yeah, so a couple of things. First of all, when Shehzad keeps on repeating since yesterday, with the garb of petulance, has to be said that yesterday said I took 6.5 minutes, whereas I took 2 minutes 40 seconds. Today twice he said you allowed Anand rather long. If you could time it, Rahul, you would get to know that Shehzad has got more time than me, but because he is my dear brother, I don't mind it at all. Number two, I think it was September 2024 when the Government of India invited people to write to the Joint Parliamentary Committee. That is when my tweet still exists. It's got 11,000 retweets, where I wrote an email to them talking about that you must repeal or remove the Waqf Act, or if not, then arm the Hindus with a similar act. Now, till that point of time, yes, I do agree that Vishnu Jain and my positions were different. Vishnu Jain was still for having the Waqf Amendment Act till, I would dare say, probably a couple of weeks ago, because he and his dear father deposed before the JPC. It was only last week that Vishnu Jain, made it known to the public that none of his recommendations were accepted by the JPC. He has a string of tweets, he has a tweet thread, and therefore now he is for abrogating the Waqf Act completely because none of his recommendations have been taken.
Okay.
That's point number one. Point number two, and I dare challenge you as well, Rahul, no one, and I do admit, yes, there was a Waqf repeal bill that was tabled in the Rajya Sabha. This is the first time hearing of it. This is the first time hearing from the mouth of a BJP spokesperson. And I dare say, if they brought in the Waqf repeal bill, where was the need to bring the Waqf Amendment Act? Because they themselves did not. Who was the one who passed this or tabled this Waqf repeal bill? Is it one of those UCC sham things that is passed by a personal member's bill? And just for the optics, Rahul, did you know of this Waqf repeal bill?
No, I didn't.
I did not.
I have to also admit I didn't. It didn't make news anywhere. It's perhaps, I don't know. Let's ask Shehzad. But Shehzad, just quickly answer that. And then I want to quickly give one small synopsis because I've run out of time.
Sure.
Yes.
Sure. First of all, I made no comment at Anand, and every viewer will testify that the only 2 times I chastise my friend Rahul, whom I have full right to because we take it in a mature spirit. Because I feel that Rahul was giving more time to Anand, but that is not commentary on Anand, it's a commentary on Rahul. But having said that, that's not the issue of the debate today at all. Both of you gentlemen, who I have great regard for and I will continue to have regard for, have admitted that you all have missed the fact that a Waqf repeal bill was also introduced. point number one, that we are not fully equipped with the facts. Both of you gentlemen are today agreeing by the end of this show that you do not have a concrete draft on the basis of which has been put in Parliament, on the basis on which you are making your commentary. Both of you gentlemen have today agreed that the likes of Vishnu Jain, whom I have great regard for, he has done great work and I will continue to bow my head in front of him, has changed his position, and that too unwittingly. And I agree and I concede that Anand may have a position which he may have taken, that I want the bill abrogated. But Anand, every law or every bill is bought not just in the context of a television debate, but in the context of a political, socio-cultural, legal, legislative reality.
Sure.
You are in TV debates, you have a full right to speak what you want. We are in Parliament, we have to also understand the context in which we are bringing this bill, whether it will pass the test of Parliament and what will be the way we can take it forward. So therefore, to think that this bill is the final destination is a big fault or is a big flaw that you are making. This is a starting step. It's an initiation.
The proof,
so don't, I would say, count your hands even before the eggs have been hatched.
Okay. On the 1st of April, viewers, we'll have the copy of the bill. We'll know exactly what amendment was passed, what was rejected, this, that, the other. We'll go over it and we'll re-invite the panelists here and we will re-engage with that subject. But there is one small thing that I want to quickly point out. You know, the business of a Sanatan board, for example, a lot of people are talking about it. Viewers, for me, I don't know how that will come to fruition. Why? Because, viewers, at the end of the day, don't forget that there are many sects within the Hindu tradition. How will we even appoint people to such a board? This is something that one needs to also focus on. It's a debate for a separate day and a debate that we must have. And I will look forward to exchanging ideas, if not arguments, with Dr. Ranganathan and Shadad Poonawalla and others who might be interested in such a subject that was once talked about by Pawan Kalyan. Yes, I leave it at this. Gentlemen, yes.
Just one small 5 seconds.
Okay, 5 seconds.
Just 5 seconds.
Yeah.
5 seconds.
Yeah, okay, both 5 seconds.
5 seconds for me first.
Okay.
5 seconds for me first.
Okay, go on,
First
5 seconds.
If I have said anything in the heat of the discussion, if I have said anything which should have been avoided to Anand or to Rahul, I apologize and I withdraw it back.
Oh, that's okay. Go ahead. Yeah.
बस कर पगले अब रुलाएगा क्या? No, I just wanted to ask because I do admit and Rahul also admitted I knew absolutely nothing about the Waqf repeal bill. But the two questions remain. Who tabled the Waqf repeal bill and why did BJP bring the Waqf Amendment Bill if it had already tabled the Waqf repeal bill?
It's an interesting question. I'll research it, viewers, and I'll tweet about it. I'll leave it at this. It's been a fine debate. Bharat's growth story is being driven by leaders transforming policy into real progress, and you can hear directly from them at News 18's Rising Bharat Summit 2025 on April 8th and 9th at the Bharat Mandapam, New Delhi. This is an exclusive opportunity to hear straight from Nitin Gadkari, Union Minister for Road Transport and Highways, on infrastructure-led economic transformation, Hardeep Singh Puri, Union Minister of Petroleum and Natural Gas, on shaping Bharat's energy resilience and global position, and Ashwani Vaishnav, Union Minister for Railways, Information and Broadcasting and Electronics and IT, on advancing digital infrastructure, mobility and communications. Get your passes today for the summit that defines what's next for Bharat.
Presented by
Donald Trump says China could get a discount on tariffs if it agrees to a US takeover of TikTok. He floated the idea in comments Wednesday.
Maybe I'll give him a little reduction in tariffs or something to get it done, because every point in tariff is worth more money than TikTok.
TikTok parent firm ByteDance has an April 5th deadline to find a non-Chinese buyer for the short video app. Otherwise, it will face a US ban over national security concerns. That had been due to kick in just before Trump took office, but the new president delayed enforcement until April. With some 170 million users in the US, TikTok's fate is a big concern for many Americans. But getting Beijing's approval for any deal has always looked like a sticking point. Trump has repeatedly used tariffs as a bargaining chip and has imposed a new 20% levy on Chinese exports since returning to power. Now he thinks China might find a discount offer tempting.
Sounds like something I did.
Vice President J.D. Vance has said he expects the general terms of an agreement to be in place by April 5th. There was no immediate comment on Trump's incentive offer from TikTok.
Another round of tariffs from President Trump before the big one due on April the 2nd. Trump has announced now a 25% tariff on all car imports into the US that he said will go into effect on April the 2nd and that he would begin to start charging the following day. These tariffs would be on top of the tariffs already in place and already announced. The US administration believes that this tax on automobiles will bring in at least $100 billion of new revenue every year, and Trump has said these taxes on automobiles will be permanent. To follow will be tax benefit offers to American buyers of cars built in the US. But this is not going to be a simple and straight tariff. A lot of the cars imported into the US come from Canada and Mexico, and these have components made in the US, and that he said will be proportionally factored into the 25% tariff. The tariffs will be reduced in proportion to the value of an imported car's American built components. This opens up a nightmare world of certification and accounting. On the other hand, to add to this, the tariff will apply to non-American components of cars built in the US. This would then be a decision particularly hard to implement. It is not clear who will police this, who will carry out inspection and certification of every car or even every lot of cars along these lines, and what the cost of all this would add up to. The automakers most severely hit will be from Mexico, where the US imported about 3 million cars last year worth about $78.5 billion. Then Japan and South Korea with about 1.5 million cars each sent to the US, Canada with 1 million, Germany with 500,000, and as expected the German cars have been on average the costliest. These 500,000 were worth about $25 billion. Exporters in all of these countries could now see a significant fall in sales, and consumers in the US a significant rise in the price of cars, which could lead to far reduced sales, which would hardly help the US economy. The silver lining on Wednesday was the announcement by Trump that come April the 2nd, he is inclined to be lenient with many countries and more lenient than he thinks they have been with the US. And many no doubt hope that will include India.
Donald Trump says China could get a discount on tariffs if it agrees to a US takeover of TikTok. He floated the idea in comments Wednesday.
Maybe I'll give them a little reduction in tariffs or something to get it done, because every point in tariff is worth more money than TikTok.
TikTok parent firm ByteDance has an April 5th deadline to find a non-Chinese buyer for the short video app. Otherwise, it will face a US ban over national security concerns. That had been due to kick in just before Trump took office, but the new president delayed enforcement until April. With some 170 million users in the US, TikTok's fate is a big concern for many Americans. But getting Beijing's approval for any deal has always looked like a sticking point. Trump has repeatedly used tariffs as a bargaining chip and has imposed a new 20% levy on Chinese exports since returning to power. Now he thinks China might find a discount offer tempting.
Sounds like something I did.
Vice President J.D. Vance has said he
Hello, Namaskar. This is First Post and you're watching Vantage with me, Palki Sharma. Donald Trump has hit top gear with his tariff plans. His latest target are cars. He has slapped a 25% tariff on car imports in America. What does it mean for car makers and consumers? How have stock markets and countries reacted, and what does it mean for India? We'll discuss all of that. Meanwhile, recession fears are on the rise. More and more experts warn of a recession in the US this year or next year. We'll tell you how that may play out